Straight ahead on Law and Crime Daily. 4 former Minneapolis police officers now indicted by a federal grand jury for George Floyd's death. Why 7 people are now facing charges after investigators say a mummified body was found in a home wrapped in Christmas lights. The alleged cult and their apparent leader now dead. And the Colorado mother missing Mother's Day last year, her husband now charged in her murder. Plus, testimony continues in the Ohio trial of a man accused of murdering his roommate, burning the dismembered remains. Law and Crime Daily covering court cases from coast to coast. Welcome everyone to Law and Crime Daily. I'm Brian Buckmire along with Terri Austin. A federal grand jury has indicted 4 former Minneapolis police officers in the death of George Floyd. Angenette Levy is here to explain what these civil rights charges mean.
Yeah, Brian, this is the federal indictment charging the 4 officers, including Derek Chauvin, in George Floyd's death. All of the officers are charged with violating Floyd's rights under the color of law.
I cannot breathe. I cannot breathe.
Federal prosecutors allege what happened to George Floyd last year in police custody was a violation of his civil rights. Specifically, the grand jury found that Chauvin placing his left knee on Floyd's neck and right knee on Floyd's arm and back until he became unresponsive and died violated the law. 2 Dahl and Alexander King are accused of willfully failing to intervene when they knew Floyd was unresponsive and didn't stop Chauvin's unreasonable use of force. A 3rd count accuses Chauvin, Dahl, King, and Thomas Lane of deliberate indifference to Floyd's serious medical needs. Former U.S. Attorney Ben Glassman explains the charges.
Deprivation of rights under color of law means that you are violating somebody else's constitutional rights and that you are doing so while you are acting with the authority of the state.
Chauvin faces 2 additional charges of deprivation of rights under the color of law for a 2017 incident involving a 14-year-old boy. Prosecutors write that Chauvin held the juvenile by the throat and struck him in the head with a flashlight several times. The teen lost consciousness. The 2nd count involves an allegation that Chauvin placed his knee on the teen's neck and back when he was handcuffed and not resisting.
This indicates to me that the FBI did a very thorough investigation and was able to generate evidence sufficient to charge for this previously unknown incident that Chauvin is also now accused of.
Jonathan McClellan heads the Minnesota Justice Coalition and had written a letter asking the DOJ for a patterns and practices investigation.
It is overdue. I'm happy that the charges and my organization supports the charges that have been levied against Chauvin and his accomplices.
And Ben Glassman told me that the charges that have been filed against these officers are actually eligible for the death penalty, but he says it's clear from looking at that indictment that the Department of Justice chose not to pursue the death penalty in this case. Brian?
Thanks, Angenette. Joining us today is legal analyst Dina, Dahl, and Terri Austin. Dina, willfully failing to intervene and deliberate indifference to medical conditions. Your thoughts on the charges for the 3 officers awaiting a state trial and the timing of it all?
I think that these charges were very reasonable and they're likely to stick because they didn't have overt acts. They did have this deliberate indifference. And so I think it will be fairly easy for the prosecution to prove. The fact that it's coming before the state means that if the prosecutors cannot convince the jury of this, the state will get a chance to see what worked and what did not work at the trial. And that will be hugely helpful to them when they bring their own case. I can see, however, these defendants wanting to do a plea bargain, especially in the state case, when we know now they're faced with this federal, maybe around the time of the sentencing of Chauvin, either soon before or soon after, we may see a plea bargain in the state case for these defendants.
Yeah, we'll see if the prosecution will extend that. Their trial is coming up this summer. Terri, appealing a murder conviction, tax charges, and now federal charges that include acts of putting a knee on someone's neck and hitting a teen over the head with a flashlight. 2021 does not look like it's going well for Chauvin. What are your thoughts?
Brian, there's no question he is going to be dealing with these legal cases for quite some time. You know, the state criminal conviction was a complete victory. It was on all 3 counts, and that absolutely meant that it was overwhelming evidence, which I think helped to lead the DOJ to actually bring their case against him. They mentioned the state criminal case when they brought the indictment. And, you know, it states that he willfully deprived George Floyd of his constitutional rights, and that related to an unreasonable seizure and including unreasonable force. So they are making sure, just like the state did, that this individual is being held responsible for his own personal actions. And I think that's going to go far as the future is concerned, and other police officers being held accountable for their individual actions as well.
And you can see the adjustment in the language in the DOJ's paperwork where they're saying that Chauvin's knee was on George Floyd's neck and back, not like they did in the state, making it very specific and very pointed. Angenette, what's next after the indictment?
Well, the three other officers, Thomas Lane, Alex King, and Tu Tao, they already made their initial appearances and were released on an appearance bond that happened via Zoom. Derek Chauvin will obviously have to make his initial appearance. He is being held in a state prison, a very secure state prison in Minnesota. And so obviously there will be a discovery process that'll have to take place with the feds. But a lot of that, they already know a lot of that information based on the state case. So there will be some discussions, I'm sure, back and forth between the attorneys and the Department of Justice in this case. And we want to tell you that we've got a lot more on this. This has been a trial that's captivated everyone's attention, and we are going to be taking a deep dive into it all weekend long on the Law and Crime Network. We are going to have a special called Law and Crime Presents inside the Derek Chauvin trial. We'll have all of the key testimony, the things that could have impacted the trial from the outside, exclusive legal analysis, and we are also going to have a discussion about these new federal civil rights charges, which we were all anticipating would take place. We had heard that a grand jury had been convened even before the state trial for Derek Chauvin took place. Brian?
Thanks, Angenette. And for more on what's going on at the Law and Crime Network, let's check in with the host of the show, Prime Crime, Jesse Weber.
Hey there, Brian. Yeah, we're discussing Anthony Kirkland, a brutal serial killer out of Ohio. And what's really chilling about this case is that it started with a missing teenager, but ended with multiple dead bodies. Like so many of the subjects we cover, it's the killer himself who walks us through these deaths.
What made you kill her? What made you do whatever you did to her? Hearing, I'm sorry, that I'm sorry.
Yeah, Kirkland's legal journey is not straightforward. There is a surprising twist. To find out what happens, tune in to Law and Crime.
Thanks, Jesse. Still ahead on Law and Crime Daily, Love Has Won takes a bizarre twist as members of the spiritual group are now under arrest. But first, when will a former Florida deputy accused of planting drugs on the job stand trial? The shocking body cam video on the other side of this break. Welcome back. A former Florida sheriff's deputy accused of planting drugs on unsuspecting motorists is set to stand trial this Monday. Zachary Wester is facing 67 charges, including racketeering, official misconduct, fabricating evidence, and false imprisonment. An investigation into Wester began in August of 2018 when the Jackson County Sheriff's Office asked state officials to look into one of their own. Prosecutors say body cam video captured the deputy putting white packets containing meth during traffic stops.
Yogurt, sir.
I know. Okay.
It's yogurt.
How about this, though?
That is not mine. No, sir.
Okay. I'm not going to ask you any
No, sir.
I'm not going to ask you any direct questions. I'm going to read you your rights first, okay? So just hang out with Deputy Hickey here.
What is it?
300 of Wester's cases have been reviewed. Charges in nearly 120 of them have been dropped. 12 victims are set to take the stand against Wester. South Carolina lawmakers are looking to bring out the firing squad, literally. Lawmakers in the Palmetto State say they face an insufficient supply of the drugs used for lethal injection and have to look for other options. 7 inmates are in line to be executed, and if lethal injection isn't available, a new bill will give the inmates a choice between the electric chair and a firing squad. The bill was approved in March by the state Senate and was voted by the House this week. It faces a routine final vote in the House before it lands on the governor's desk for approval. 7 members of the spiritual group Love Has Won have been arrested in Colorado. Authorities say the body of the group's leader, Amy Carlson, was found mummified inside a sleeping bag at a home in Crestone. According to a sergeant searching the home, the remains were decorated with Christmas tree lights and set up in, quote, some kind of a shrine with glitter makeup on the body's eyes. The man who tipped off authorities reportedly believes members drove the body from California to Colorado. The sheriff's office says they have received complaints from families claiming the group is brainwashing people and stealing their money. Investigators also found a 2-year-old boy and 13-year-old girl sleeping in the home. The 7 people are facing charges of abuse of a corpse and 2 counts of child abuse. Back with us is legal analyst Dina Dahl and Terri Austin. Terri, abuse of a corpse and child abuse are the only charges so far, but an autopsy hasn't come in yet. Should we be expecting an upgrade in charges when it does?
Absolutely, Brian. There's no question. I think what the authorities were trying to do here is to make sure they had enough probable cause to support the charges that they have. And the charges that they have right now are the abuse of the corpse and the fact that, they may have molested these children, or not taking good care of them. But in a sense, it does remind me of the Lori and Chad Daybell case, because you're going to bring the charges you can support until you get more evidence. And once they have a corpse and an autopsy, they're going to be able to determine the manner and cause of death once the autopsy comes back. And then they'll be able to say that this is what the event was, and this is what caused the death, and this is why we can bring these murder charges. So hopefully that will happen here.
Yeah, we'll make sure to check out the cause and also other aspects of that medical examiner report. Now, Dina, you came up with this idea that could it be possible for the religious group to argue under the First Amendment, some sort of religious freedom, for the charges like abuse of a corpse or others, because it doesn't really seem like they were abusing her corpse, more like honoring their leader?
Yes, exactly. And under the law in California, their abuse of corpse is that it's outrageous to normal family sensibilities. But you do have an intersection there of freedom of religion, because what is okay maybe for one religion would not be for another. It does seem here with the lights and the glitter that they were either worshiping her or trying to honor her. Whether or not that can legally stick, we could assume if they did not actually kill her, but this is on trial, that we will see this argument that they did it not for the purposes of abusing her, but honoring her in some way. So even if legally they can't make the freedom of religion work, it still might be persuasive to some of the jurors.
Makes sense. Some people get cremated, some people get buried underground, some people put their bodies out to the ocean. So maybe this is for their religion, that. Nice idea. We'll see how it works out. Coming up on Law and Crime Daily, an Ohio detective takes the stand in the case of the dismembered roommate. Plus, a Mother's Day tragedy. The mother reported missing in Colorado on Mother's Day 2020. Why her husband is now behind bars. Next. We're back. The husband of a missing Colorado mother has now been charged with her murder. 49-year-old mother of 2, Suzanne Morphy, was reported missing by her neighbor on Mother's Day 2020. Just 7 days later, her husband, Barry Morphy, took to social media pleading for her safe return.
Please, we'll do whatever it takes to bring you back. We love you, we miss you, your girls need you. No questions asked. However much they want, I will do whatever it takes to get you back. Honey, I love you.
But after searching for nearly a year, including 135 search warrants and more than 400 interviews, investigators now believe her husband is responsible for her disappearance. Barry Morphy was arrested this week on charges of first-degree murder, evidence tampering, and attempting to influence a public servant. Here to discuss the missing mom of Mother's Day is legal analyst Dina Dahl and Terri Austin. Terri, What are your thoughts about the heartfelt plea from Barry Morphy? That's definitely going to come into trial. Do you think he's a criminal mastermind or a loving husband and father?
You know, I think depending on the evidence they have, I think the jury is going to think he's a criminal mastermind and not a loving father. Anytime you have family members or someone who was the last person to see someone, obviously that individual is a suspect. And the jury knows that. They're thinking about that case. And clearly, if he was represented by an attorney at that point, which it doesn't sound like he was, he would not have gone onto social media to plead his case. And that will be introduced into evidence, and it'll give the jury an opportunity to decipher, is he telling the truth? Why is he doing this? And it could very well be used against him.
Now, Dina, I can see this taking quite some time to get to trial and be a massive trial. 135 search warrants and 400 interviews across multiple states. What do you think the prosecution is going to look like in this case?
So far, they have revealed very little information, and so we don't know that many details. I'm hoping, because they don't have a body here, that although they were far and wide in their collecting of evidence, that they are very narrow and specific in their scope, because without a body, they're going to just have circumstantial evidence and they can confuse the jury. But it sounds like the sister of the victim already believes that he is guilty. She said she's in fact already forgiven him. So, you know, that's not a good sign, that she might know kind of more than we do at this point. And there may be some very strong evidence against him. They just really have to reel it in and keep it very specific.
It's definitely going to be a lot of information. We'll see how the defense handles that when the trial comes up. When we come back, prosecutors claim an Ohio man dismembered and burned his roommate. What the investigating detective reveals on the stand on the other side of the break. Welcome back. Graphic testimony is underway in the Ohio trial of a man accused of killing his roommate and burning his body to hide the evidence. Michael Dixon is on trial for murdering, dismembering, and then burning the remains of his roommate, Jim Whitaker. The 41-year-old Dixon admitting to killing, but claims it was self-defense. Prosecutors say it was murder. One of the investigative detectives says Dixon led them to the remains after confessing.
That is Mr. Dixon pointing to the burn pit, the area that he felt that Mr. Whitaker was located in. Mr. Dixon talked in his interviews, the shot shell that he used to kill Mr. Whitaker, it was in a clear case, a clear shell. This was a clear shell that we found that was discharged in the basement. This is a chainsaw blade that we recovered in the burn pit as well. And it looks like it was burnt in the burn pit. From the anthropologist, we found out that the bones that we recovered of Mr. Whitaker's, it had sharp cuts from a sharp instrument, but it also had other edges that would be consistent with being cut up with a chainsaw blade. These are the bones the anthropologist pointed out. Hey, these are probably most likely human bones. And we went back on a search warrant and collected these bones.
On cross-examination, the defense asked the detective if investigators would have ever found the remains if not for their client.
But when you mentioned on the stand earlier, you said that you wouldn't have even thought to look in the burn pile until he told you. Is that accurate?
That is inaccurate. We actually searched that area by cadaver dog earlier that week. So that area was searched.
Okay. But you ended up doing a thorough search where you started excavating after he told you to look there, correct?
That is correct.
Okay. And when he told you to look there, you eventually found some of the remains, correct?
That is correct.
So that would be a consistent statement that he made, correct?
That was a statement made true, saying that Jimmy was in there, yes.
And you said that it took quite a while for you to excavate that area, correct?
Yes.
In fact, you said that you had to go back 2 different times. It took you several hours, correct?
No, we went back to the burn pit 1 additional time. 2 times total.
2 times total.
That
and
is
then
correct.
Several hours each time, correct?
That's correct.
Let's bring in Dina and Terri to discuss Dixon's defense one last time. Dina, the defense argued Dixon, a drug addict, believed it was reasonable to burn and discard a body. Does that help the defense in any way?
I don't think it does, because it's not reasonable. And so it doesn't necessarily matter that whether or not he was a drug addict or not. It's similar maybe to say, you know, he wouldn't have hit that car if he hadn't been on drugs. You know, at the end of the day, you can't burn the body, and it's not a defense under the law that he may have done it anyway because he was either on drugs or perpetually on drugs he no longer thought. The fact is, it was not reasonable, and it's not a valid defense.
Yeah, I think a lot of people, myself through my clients, know a lot of drug addicts. Not all of them are burying bodies and burning them, so I don't know if that's going to work. And then, Terri, kind of with that, could a poor explanation of why the body was disposed end up hurting Dixon in the long run when trying to beat that top charge of murder?
Brian, you know, honestly, it's never easy to explain to a jury why you cut up a body, put it in a burn pit, and try to burn up the remains. It clearly is a consciousness of guilt. And any explanation, I think, is going to backfire, and the jury's probably going to think this was a cold-blooded murder, this was not self-defense or anything else like that, because if it had been, why would he be trying to destroy the body and get rid of all of the evidence? So I think whatever explanation he's trying to give here is not going to suffice. And I do think the jury's going to think, because you did all of this, it must mean that you are guilty of murder.
Yeah, and the law at least has this charge called falsus in uno, falsus in omnibus. Basically, if you're false in one thing, you're false in everything. And so that may kind of hurt the defense here. Even if that charge is not there, that concept still works really well. Dina, Terri, I want to thank you very much for joining us today and contributing. And I want to thank you for joining us here at the Law and Crime Daily. We'll see you next time as we discuss justice in America.